According to Article 1207, the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability on when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. According to Article 1208, if from the law or the nature or the wording of the obligation to which of the preceding articles refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. Kinds of obligation according to the number of parties. They are: first, individual obligation. There is only one debtor and one creditor in a contract. And second, collective obligation. There are two or more debtors and two or more creditors. Next, meaning of joint and solidary obligation. First, joint obligation, where the whole obligation is to be paid or fulfilled proportionately by the different debtors and demanded proportionately by the different creditors. This is the presumption in all collective obligation unless solidarity is expressly stated. And second, solidary obligation, where each one of the debtors is bound to render, and or each creditor has the right to demand it from any of the debtors the entire compliance with the prestation. Next, collective obligation presumed to be joint. First, if A is liable to B for 9,000, there can be no problem regarding the termination of the following. First, the person liable to pay, the person entitled to demand payment, the extent of the liability of the debtor, and the extent of the right of the creditor. Second, where there is a plurality of parties, two or more debtors and two or more creditors, and the share of each in the obligation is specified, the correlative rights and the obligation of the parties are known. Thus, if A, B, and C are liable to D in the amount of 9,000, it is stated that the corresponding share of each debtor is 3,000. It may be in unequal amounts. We know that A, B, and C are liable only for 3,000 each, and that D is not entitled to collect from each debtor more than his corresponding share in the obligation. Third, on the other hand, let us suppose that in the same obligation that shares of each debtor or the shares of each creditor, if there are two or more creditors, is not specified. What is the extent of liability of A, B, and C? In such case, the presumption is that the obligation is joint, and as a consequence, first, there are as many debts as there are debtors. There are as many credits as there are creditors. The debts and or credits are considered distinct and separate from one another. Each debtor is liable only for a proportionate part of the debt, and each creditor is entitled only to proportionate part of the credit. Next, presumption subject to rules on multiplicity of suit. The presumption in Article 1208 is made subject to the rules of court governing the multiplicity of suits. Otherwise, situations may arise where there are as many suits as there are debtors and creditors. Rules on multiplicity of suits seek to prevent the filing of two or more suits or complaints for the same violation of the legal right of the plaintiff. Next, words used to indicate joint liability. Other words used for joint obligations are mancomunada, mancomunadamente, pro rata. Proportionately, we promise to pay signed by two or more persons. Next, when obligation solidary. Solidary liability is not lightly inferred. Under Article 1207, there is solidary liability only when, first, the obligation expressly so states, or second, the law requires solidarity, or third, the nature of the obligation requires solidarity. Solidary liability also exists when it is imposed in a final judgment against several defendants. Next, words used to indicate solidary liability. It is not necessary that the agreement should employ precisely the word solidary. In order that an obligation may be considered, it is sufficient that the obligation declares, for instance, that each one of the debtors can be compelled to pay the entire obligation, or can be proceeded against for the full amount of the obligation, etc. Next, kinds of solidarity. They are, first, according to the parties bound. We have passive solidarity. One of the several debtors can be made liable for the payment or the performance of the entire obligation. And we have active solidarity. One of the solidary creditors can demand the fulfillment of the entire obligation from the debtor or any of the debtors. And also we have mixed solidarity. Solidarity on the part of the debtors and creditors, where each one of the debtors is liable to render and each one of the creditors has a right to demand entire compliance with the obligation. Second, according to source, we have conventional solidarity, where solidarity is agreed upon by the parties, and legal solidarity, where solidarity is imposed by the law, and also we have real solidarity, where solidarity is imposed by the nature of the obligation. Next, solidarity not presumed. The presumption where there are two or more persons in the same obligation is that it is joint. The reason is that solidary obligations are very burdensome for they create unusual rights and liabilities. Solidarity between debtors increases their responsibility, while solidarity between creditors increases the right of each creditor. The law tends to favor the debtors in presuming that they are bound jointly and not solidarily. According to Article 1209, if the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. Next, joint indivisible obligation. The obligation is joint because the parties are merely proportionately liable. It is indivisible because the object or subject matter is not physically divisible into different parts. It is joint as to liabilities of the debtors or rights of the creditors, but indivisible as to compliance. This obligation constitutes the middle ground between a joint obligation and a solidary obligation. According to Article 1210, the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. Next, indivisibility and solidarity indistinguish. The differences are, first, indivisibility refers to the prestation, while solidarity refers to the juridical or legal tie that binds ties. Second, in indivisible obligation, only the debtor guilty for breach of obligation is liable for damages, while in solidary obligation, all of the debtors are liable for the breach of the obligation committed by a debtor. Third, indivisibility can exist although there is only one debtor and only one creditor, while in solidarity, there must be at least two debtors and two creditors. And four, in indivisible obligation, debtors are not liable in case of insolvency of one debtor, while in solidary obligation, the other debtors are proportionately liable. The first sentence of Article 1210 simply means the liability in an indivisible obligation may be either joint or solidary. The second sentence means that in a solidary obligation, the subject matter may be divisible or indivisible. According to Article 1211, solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Next, kinds of solidary obligation according to the legal tie. They are, first, uniform, when the parties are bound by the same stipulation or clauses. Second, non-uniform or varied, when the parties are not subject to the same stipulation or clauses. Next, solidarity not affected by diverse stipulations. Essence of solidarity consists in the right of each creditor to enforce the rights of all, the liability of each debtor to answer for the liabilities of all. Therefore, there may be a solidary obligation although the parties may not be bound in the same manner and by the same periods and conditions. Action against any of the solidary debtors. Creditor may bring his action in toto against any of the solidary debtors less the shares of the other debtors with expired terms or unfulfilled conditions who are entitled to defenses under Article 1222. Upon the expiration of the term or the fulfillment of the condition, the creditor will have the right to demand by the payment of the remainder toto its entirety or completely. For example, if a judge accepts lawyer's argument in toto, it means that the judge accepts the whole thing. However, the parties may stipulate that any solidary debtors already bound may be made liable for the entire obligation. According to Article 1212, each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Next, act of solidary creditors, useful or prejudicial to others. A solidary creditor may do any act beneficial or useful to the others, but he cannot perform any act prejudicial to them. If he performs such act and as a result to the obligation is extinguished, he shall be responsible to the others for damages. As far as the debtor or debtors are concerned, the act shall be valid and binding. The rule is based on the theory of mutual agency. Among the solidary creditors, a joint creditor cannot act in representation of the others. According to Article 1213, a solidary creditor cannot assign his rights without the consent of the others. Next, assignment by solidary creditor of his rights. In the absence of consent given by the others, a solidary creditor cannot assign his rights to the third person. The reason behind this prohibition is that each creditor represents the others and the assignee may not have the confidence of the original solidary creditors, considering that the assignee after receiving payment may not give the shares of the others. If the assignment is made to a co-creditor, the consent of the other creditors is not necessary. According to Article 1214, the debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Next, payment to any of the solidary creditors. The rule is that the debtor may pay any one of the solidary creditors, but when a demand, judicial or extrajudicial, has been made by one of them, to avoid confusion, payment shall be made to him. Otherwise, and the obligation will not be extinguished except insofar as the creditor pays share is concerned in case the latter does not give to the other creditors their shares in the payments. The demand has the effect of terminating the mutual agency among the solidary creditors. According to Article 1215, novation, compensation, confusion, or remission of the debt may be any of the solidary creditors or with any of the solidary debtors, shall extinguish the obligation without prejudice to the provision of Article 1219. The creditor who may have executed any of these acts, as well as he who collects the debtor, shall be liable to the others for the share in the obligation corresponding to them. Next, liability of solidary creditor in case of novation, compensation, confusion, or remission. Novation, compensation, confusion, and remission are modes of causes of extinguishment of obligations. It is but logical that the creditor who executed any of these acts should be liable to the others for their corresponding shares, considering that such acts are prejudicial to them. Next, effect of novation, etc., where obligation joint. This does not extinguish or modify the obligation except with respect to the creditor or debtor affected, without extending its operation to any other part of the debt or of the credit. According to Article 1216, the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them will not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. Next, right of creditor to proceed against any solidary debtor, not applicable to a joint obligation. It reiterates the rule that in a solidary obligation or passive solidarity, any one or some or all of the solidary or debtors simultaneously may be made to pay the debt so long as it has been not fully collected. The choice is left to the solidary creditor to determine against whom he will enforce collect. According to Article 1217, payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, his share to the debtor paying the obligation. Such share should be borne by all his co-debtors in proportion to the debt of each. Next, effects of payment by a solidary debtor. First, between the solidary debtors and creditors. Full payment extinguishes the obligation. However, the creditor for his protection is given the right to choose which offer to accept if two or more solidary debtors offer to pay. Second, among the solidary debtors. Paying solidary debtor can demand reimbursement from his co-debtors for their proportionate shares with interest only from the time of payment. Third, among the solidary creditors. The receiving creditor is jointly liable to the others for their corresponding shares. According to Article 1218, payment by a solidary debtor shall not be entitled him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Next, effects of payment after obligation has prescribed or become illegal. When a solidary debtor pays the obligation, he is entitled, as a rule, to a reimbursement from his co-debtors. Article 1218 mentions two cases when the paying debtor cannot get any reimbursements. When the obligation has already prescribed or become illegal, the obligation is extinguished. Hence, there are no more obligations to be complied with. Next, prescribed periods of actions. By prescriptions, one acquires ownership and other rights through the lapse of time, the manner and under the conditions laid down by the law. In the same way, rights and actions are lost by prescription. The following actions must be brought within 10 years from the time the right of actions accrues. First, upon a written contract. Second, upon an obligation created by law. And third, upon a judgment. The following actions must be commenced within 6 years. First, upon an oral contract, and second, upon a quasi-contract. The following actions must be instituted within 4 years. First, upon an injury to the rights of the plaintiff, and second, upon a quasi-delict. The statute of limitations, however, may be superseded or modified by a contract between the parties. According to Article 1219, the remission made by the creditor of the shares which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors, in case the debt had been totally paid by any one of them before the remission was effected. Next, effects of remission of shares after payment. If payment is made first, the remission or waiver is of no effect. There is no more obligation to remit. If remission is made previous to the payment and payment is made, solutio indebiti arises. It is incumbent upon the debtor whose debt is remitted to prove the priority of the remission to the payment to release him from the responsibility towards his co-debtors. Article 1219 forestall fraud whereby the debt having been paid. The creditor who does not stand to suffer any loss or damage remits the share of a particular debtor, also secures equality and justice to the paying debtor inasmuch as the payment benefits his co-debtors. According to Article 1220, the remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursements from his co-debtors. Next, no right to reimbursements in case or remission. The debtor who obtains remissions pays nothing to the creditor. Remission is essentially gratuitous. It is really a donation. Observe that the article applies only when the whole obligation is remitted. In case of novation, compensation, or confusion, and the debtor with whom it is affected is entitled to recover from his co-debtors their corresponding shares of the obligation. According to Article 1221, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor for the price and the payment of damages and interest without prejudice to their actions against the guilty or negligent debtor. If through a fortuitous events, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. Next, rules in case thing has been lost or prestations has become impossible. The liability of the solidary debtors depends upon whether or not there is fault or delay. First, loss is without fault and before delay. Second, loss is due to fault on the part of a solidary debtor. And third, loss is without fault but after delay. According to Article 1222, a solidary debtor may actions filled by the creditor avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him or pertain to his own share, with respect to those which personally belong to the others. He may avail himself thereof only as regards that part of the debt for which the latter are responsible. Next, defense available to a solidary debtor. In actions filled by the creditor, a solidary debtor may avail himself of the following defenses. First, defenses derived from the nature of the obligations. It is complete defense. And second, defenses personal to or which pertain to share of the debtor sued. We have complete defense, insanity, incapacity, mistake, violence, minority. And partial defense, non-fulfillment of offensive condition. And third, defenses personal to the other solidary debtors. It is partial defense.